much later, and the president didn't need to sit in the as head of government, head of state. The president did not need to always sit and answer questions in the House. Much later in 2010, we said that let the top of the executive, the president, the deputy president, not sit in our houses, and the cabinet ministers as well, or cabinet secretaries as we now call them. And we've realized, Kenyans realized in BBI report 1 as well as the validation report 2, that those models that came from the UK, our former colonial masters, or they came from the US, have not worked for us. So in summary, Kenyans are saying let us do a hybrid model of presidential and parliamentary system whereby the top of the executive will be in the House. In BBI, we used to call it autochthony, autochthonous, homegrown, home-based, our own historical experience being brought to bear. Chapter 9, Mr. Chairman, is about the executive. And again, you will see that there's an executive legislative power structure. But here, let me just focus on the executive, whereby, of course, there is no fundamental change on the presidency, on the president or on the deputy president, president or deputy president. The idea, but there is reintroduction of a prime minister, and for the avoidance of doubt, we had a prime minister at independence, Prime Minister Jomo Kenyatta. We had a prime minister in 2008, 2013, Prime Minister Raila Odinga. So we have had experience with the prime minister, and Kenyans said that bring that office back. And as you bring back the prime minister, and in a different model, of course, with the deputy prime ministers, etc., the idea that Kenyans said in the BBI reports 1 and 2 is that please avoid two things. One, please avoid imperial president. And number 2, avoid the idea that we will create two antagonistic centers of power. So those are the models that Mr. Tom Macharia and all of us will remember that we were working with on the advice of Kenyans. Avoid imperial president, avoid two centers of power, but let them share power. And you will see that the BBI, the 2010 Amendment Bill, proposes that there be a prime minister, for example, who will chair cabinet committees. And this is not a super CS. Not at all. This is a prime minister who is the leader of a party, which has majority in the House, or the leader of a coalition of parties that is majority in the House. So they don't come from just mere appointment in one morning. Secondly, this is also a prime minister who has constitutional authority, whose powers are given by the constitution, or the people, the constitution, and statute. Of course, some powers can also be given by the president. So these are some of the issues that are important in protecting Kenya's future. Shared prosperity, inclusivity, including winner doesn't take it all. You will see, for example, in the legislature, when you are talking about party list, a party will earn those seats based on the votes that it earned, not on the seats that it won. Received, which is a very major change. Lastly, as I hand over to my colleague who was the co-chair of the team of experts with me, Mr. Tom Macharia, who was a co-chair with me on the team of experts, the last point I would make is that there is also Article 230 on SRC issues, and SRC has a very major role to make sure that we rationalize and harmonize remuneration and pay in public service, and this will help the public service, will help also give leadership in the private sector, so that all of us have shared productivity, which Honorable Nyakabi talks about, and shared prosperity and inclusivity in the economy. Mr. Tom Macharia, Advocate Tom Macharia, please.
Thank you very much, honorable members of the Senate and of the National Assembly. I'll speak briefly on the question of representation, and in particular about the question of increase of constituencies in the bill. Allow me to speak straight to the question of the principles that were involved. As I think you know, the bill proposes to increase the number of constituencies in Kenya from 290 to 360. That is number one. Number two, there was a question, and I think my colleague and learned friend Priscilla Nyokafi said she would speak to, which is the question of achieving the two-third gender rule. Allow me to speak to the first question. When the steering committee and the task force before it started to look into this question, they reviewed a lot of material. Thank you very much. They reviewed quite a bit of material, and as Honorable Dennis Waweru had said earlier, a lot of it is set out in the annex to the BBI report. But as regards the boundary delimitation, these were the principles that were involved and that guided that process. Now, as members of these honorable houses will be aware, and of the Joint Committee will be aware, in 2012, following the promulgation of the Constitution of Kenya 2010, the IBC was mandated to delimit boundaries and came up with a report which was submitted to both houses, these houses of Parliament, which is called the Revised Preliminary Report of the Proposed Boundaries of Constituencies and Wards. That was one of the resource materials that was looked into, and I'll say a bit more about that as we go along. So those observations from the last delimitation process, that's number one. Number two, there were principles that arose from a court case that was filed. Actually, there were several cases that were filed at that time. There was one that followed the boundaries delimitation process itself. And there was one, a case known as John Kimanthi Maingi versus Andrew Ligale and others, that was filed and determined in the course of the process. The other one were principles that were identified by the IBC at the time, and which are in the report I've just referred you to, which were the nexus between resources, or at least in the minds of Kenyans, the nexus between resources and boundary delimitation. That was the other one. The other one, of course, was the fact that, as I think the promoters here have said earlier, the BBI process itself was triggered, I should say, by a disputed election in 2017. And so the area of consensus building and some of the issues that arose, or the lessons learned from that process, were one of the other issues that was then used to determine this. The other one, of course, was that the IBC itself has actually begun the process of delimitation, and I think you may recall there was a statement they issued in early January 2020. And then, of course, under the report that I've just referred you to, the IBC had indicated in their 2012 report that even as they began the process, just like BBI has done, they were guided by law and required to be guided by a report prepared by the IIBRC at the time, the Interim Independent Boundaries Review Commission, and the Justice and Legal Affairs Committee of Parliament of this house itself was one of the guiding documents they were required by law to follow. And so they too were guided just as BBI seeks through the sovereign will of the people of Kenya to guide them to do. On top of that, you will recall in 2012 that we began with 210 constituencies. Those through the process, and there's a lot of mathematics and a lot of material set up in that report, and I can't get into all of it now, and you'll be able to see that later. That number was then added to become the number we now know to be 290. But of course, apart from the 290, you have the 12 nominated, and you have the 47 women rep members. So at least in the National Assembly, we are talking about 349. And so the average number of people represented in those, by those 349 people is 136,000, which became the population quota that we used for purposes of determining whether, as I think some of my colleagues here have said, the principle in Article 89, Sub-Article 7, had been complied with. And that's also in the report here that IBC had prepared. And I think, of course, I should add here that IBC themselves did submit a memorandum to BBI when the process began. On top of that, one of the other principles taken into account was that in 2012, and they're listed here, they're also in the report identified 27 protected constituencies in Kenya, and they're listed there where all of them are. And of course, the point was that those constituencies did not meet the population quota that Article 89 prescribes. Apart from those 27, you have another group of about 8, which in the near future, with 18,000, 20,000, or 30,000 people, are nowhere near meeting the population quota and are unlikely to do so. So these were all the principles that were then applied to the process of determining. And then I think I should add as well, on top of that, in 2016, the Auditor General at the time, Mr. Uko, I believe, audited the impact, the socio-economic impact of implementing the Constitution of Kenya 2010. Among the things he did was to examine a question that is sometimes, I think, a bit of a tortured, and that also came to the task force and subsequently to the steering committee, is whether Kenyans are overrepresented. He actually examined that question. He did a lot of data. He went around the world. He took the numbers from many other countries, and you can be able, I believe the report was actually submitted to Parliament as well. Among the things noted there, and it's been noted elsewhere by other experts apart from the group represented here, was that the International Parliamentary Union cites a number of 123,000 people as the average number of people an MP should represent in the category Kenya is put under by the IPU. It may interest you to also know that in 2010, the average number of people represented by MP was 133,138. So that's the number, 135,000, that was then used to determine whether there's adequate representation. And the point here, of course, was to address very wide disparities. So on the one hand, there was a need to protect constituencies. You know, like I said, have 20,000 people. And but there was a need then to achieve the equality of the vote principle in Article 81, Sub-Article D, I believe it is, that there should be equality of the vote. You know, constituencies that have 800,000 people, 500,000 people, 300,000 people. So those were the principles that then led to the addition of the 70 over the 290, so that you then have 360. But those 360 then do not have the position of women rep. And as I think Priscilla said, she'll be speaking to that on the question when she addresses the question of gender. So you end up with 360 directly elected first past the post members of parliament in the National Assembly. You end up with 94 senators, 1 man and 1 woman per county. The principle, again, as we agreed in 2010, as a people in Kenya, was that the Senate represents the interests of the counties and the county governments. So there is an equality principle that is applicable there. There is then, of course, the question of the 2/3. And we examined the 5, I believe there have been 5 constitutional bills that have come before Parliament to try and address the question of the 2/3. We looked into that question. We looked into the recommendations made by some of the reports I've cited here before, the mixed member representation proposals, the full, you know, just like South Africa, the proportional representation model, and various other models that were looked into. The solution was to come up with top-ups, as we do have now in the county assemblies, but for a limited period of time, because affirmative action is always limited to the next 3 elections, and that's just for the National Assembly, whereafter we revert to direct first past the post competitive process for both men and women. And that's how the question of representation then was resolved, and how we ended up with the 360 and the top-up positions that I've referred to there. On account of time, allow me perhaps to move on to the next question.
I think, Council Macharia,
yes.
if, your group has already taken about 45 minutes.
Yes.
So if you can, the principals, if they can wrap up.
Yes.
Because don't, with a lot of respect, don't load too much background
Yes.
information.
Okay.
So, because your case is very clear,
Thank you.
I think you just summarize, and you can see groups are becoming impatient
Yes.
because you are timed.
Thank
So
you.
try to wrap up as soon as you
I will wrap up in 3 minutes. The last 3 issues allocated to me, one was the issue of the ombudsman. As I said, you will note that the position in the bill is now not the same position you had when the report was released. This was to take into account concerns raised by Kenyans as to the independence of the judiciary. The ombudsman will be a non-voting member of the JSC and will not be capable of removing any judges, directly he or herself. And thirdly, the decisions of the ombudsman will not lead to the review of any cases that would impinge on the decisional independence of the judiciary. So the Ombudsman, again, views by Kenyans on independence taken into account. Devolution, I think, I need not say too much about this. In summary, 35% from 15% increased to the county allocation. There's a question about the role of MCAs. MCAs can now be appointed as CECs. The county assemblies should have their own county assembly funds. The introduction of a ward development fund. Perhaps I can take into account this as well, the constitutionalization, to deal with the questions that Parliament has faced in court over the CDF. CDF now entrenched in the Constitution. The Senate, a recommendation, as we currently see it today, the Senate doesn't have power to oversight the expenditure of counties. It only oversights by the Constitution the revenue. So there's a proposal to amend that to include oversight over the expenditure and all the revenue that comes into the county assemblies. Some proposals around gender parity in the position of the governor and the deputy governor. Proposals as to the Article 43, impact assessment and monitoring in budgeting and through the presidential address as well. There are also questions about, there's been a reduction in the number of members of the SRC Salaries Review Commission from 14 to 7 to be in harmony with all of the other members. And I think those are the main pointers, but the rest, as you'll see, are set out clearly. So that's about devolution, but there's a lot more we could say, but due to time, I will pass over that. Finally, on questions of security and the police, there has been a question about the harmony of mandate between the National Police Service Commission and the Inspector General. That has now been harmonized. Again, as with the Ombudsman, again following comments and issues raised by Kenyans after the report, that was also slightly altered so that the National Police Service Commission retains its mandate, other than that the mandate of disciplining police is clearly with the IG. There's a clear mandate under the IG. The DCI introduced as the third force in the police force, and maybe to add something about the DPP. The DPP is currently of the rank of a high court. That has been, the proposal is to enhance that to the rank of a court of appeal judge, and to make that an independent office to strengthen the fight against crime and corruption in this country. So in a nutshell, Mr. Chairman, allow me to wrap up my presentation at that point in time. Thank you very much.
Thank you. Chairman, we are going to take under 2 minutes, and it's clear from what we have found out from Kenyans is we need a more balanced hybrid system where we have checks and balances, but at the same time, the two arms of government can be interdependent of to each other. And also, I think it has come out very clear on the gender issue. We have to push that gender parity into the political parties in the 360, and that is one of the recommendations that we are doing. I want now to invite my co-chair to conclude, and then we can wrap it up there. Thank you very much, co-chair.
Thank you very much, Honorable Chair. The principles that are based on this document have been well put out by our experts. The only thing I want to add is that the issue of representation, the issue that was raised by the Law Society of Kenya on the delimitation, I think that issue has been addressed by Advocate Tom Masharia, that this document is only setting the number at 360, but the delimitation will be done by IEBC as required by law and the Constitution. But having said, Chair, now that the committee is doing their hearings in public, I could follow in the morning what the LSK has presented, and that I don't think those are first the views of the LSK, because, Chair, this process has been very participatory, it has been open, it has been transparent, and Kenyans were given time to exercise and participate. If you choose, if you don't participate by choice, nobody can force you to choose, Mr. Chair. And lastly, we should not put personal views as views of the LSK, Chair. LSK is a respected organization in this country. your co-chair has been a distinguished chair one time. So if your views are aligned politically to certain direction, for example, if you are aligned to Tangatanga,
Chair,
just say
point of
that is
order.
your personal view, Chair.
Chair, point
Thank you
of
so
order.
much, Chair.
Chair, is it in order for the promoter to comment on issues of LSK when the chairman or the president of LSK is not present? He was here, and that time the promoter ought to have been here to ask those questions. It's not fair for LSK chair.
You see, with a lot of respect, we don't want to go rigoristic because we are not in a court of law. We are loose and we are taking all views. It is good to hear a divergent view when it is expressed. However, whatever source, right? We can't just confine and say this. I think it's in order. Any view that comes to us is interesting because a case has been made. Let us see also a divergent view. I think carry on with a lot of respect to you. Let Mheshimiwa carry on. Carry on.
Thank you, Chair, for your
And,
protection. Chair, I'm concluding.
And it is,
I'm concluding, Chair, by saying that I urge the committee to consider this bill, Chair. And as you said, that we have to hear different views, Chair. And I'm sure what was presented here was not the views of 18,000 members of the Law Society. It was an individual view. And you know, people have different inclinations, political, as I said, Chair. And I listened to it here. I was here listening, Chair. And I think we should desist from politicizing this document in a manner that is going to make Kenyans feel, confused, Chair. So, Chair, you are a distinguished lawyer yourself. You know that the Law Society of Kenya has been reduced at the moment to a village, organization kind of, by the current Chair. With those few remarks, I conclude, Chair. Thank you.
it is important. It is important before perhaps you leave, if Councillor Macharia could comment. The thrust of the RSK objection when they raised their objections.
A point of order, Chair.
Yeah,
My name's Honorable Malwa. The point of order, Chair, is I seek your direction. Is Honorable Junet in order to impute improper motive about LSK? Because as a body comes here to present, it's an assumption that it was through a consultative and participatory process.
Point of
But-
order, Chair.
But for him to come and say,
Point of order, Chair.
There's a
to
more
a village, he should withdraw that, Mr. Chair.
No, Chair. There's a more fundamental issue before that point of order. Is whether the Honorable Chris Wamalo can raise a point of order, not being a member of the Joint Committee. And secondly, not having been here when we interrogated the issue.
that is what.
I thought
Let me rule. That is.
this is Parliament. I'm a parliamentarian, Mr. Chair.
Don't worry. Don't worry. Whatever we are saying, we are a bit informal because this being an open forum, public forum, I think is not in order to introduce improper motive. The rest I accept. Junet, we are not. Any member who comes here, let us not impute any other motive.
Yes.
He's come here to present views, so whether in order, whether improper or not, we want to hear everybody. Let us, otherwise people will fear coming here and say, look. But I wanted for us to save time. I have ruled on that, but on behalf of my chair, we have ruled that. But
Chair, we are.
I agree with Otiede that member, Dr. Chris is not really a member of the, substantively is not. He's entitled to sit here. But because we are hearing views, let us hear from even strangers. If they put their views across, we'll hear, right? But before we wrap, I wanted Macharia to, the thrust of the RSK, or the members, the loose members, the 5 members who came, they raised objection on clause 61, that it curtails, it doesn't give it curtails their freedom to contract. 61, I think, was it 3 or 4? Yeah, you have it, Machari, on your fingertips. See, the one which talks about harmonize. Is it not 61? The new clause 61. The new 61. Yes. 61 on the bill. The new clause that is seeking to harmonize remuneration of professionals, right? They said that the thrust was that was an intrusion into their freedom of contract on their fees. Any comment? Yes.
And through Chair, I think to clarify, at page 27 of the LSK's memorandum, if you can read it there, the concern the Law Society of Kenya raised before us is that what they have an issue with is what is in the second schedule of the amendment bill that proposes to create new constituencies and, using their own words, purporting to allocate them to different counties. And they say that is an usurpation of the constitutional role of IBC. I think that's the issue they have. They say it is okay to propose a creation of 360 constituencies, but they say you cannot proceed to allocate those constituencies to particular counties. I think that's the issue that they raised before us. And they also pointed out that under Article 89, you cannot do that before you consult the affected people and all interest group from those particular regions. I think that's the issue that was raised with, and we seek your comment on. Honorable Tiandamol.
Thank you, Chair. A comment and then two questions. First, I thank the team for the presentation, especially the fact of introducing the entire report, not just the bill, because as we understand it, that there are other considerations which are supposed to come under statutory interventions. And that leads me to my first question. Have you been able to isolate the specific statutory interventions that are required and to prioritize them, to list them in order of priority? Because I think it would be helpful to share with this committee. But the second one,
determine fees charged by professional bodies. What's your take on that?
Just to advise you, Honorable Mutai, that 89.4 has been suspended regarding this particular amendment on the second schedule. If you look at page 28 of the bill.
Page?
28 of the bill. Subclause 6. But Honorable Gishimu, MP for Gishimu.